Hello and welcome to today's video. Today we're looking at intellectual property. So we're going to try and introduce you to the just a basic understanding and the concepts of intellectual property and a little bit of an introduction to how each of these intellectual properties work: patents, trademarks, copyright, and trade secrets. So we're going to look at the four of those as well. Um, and I think it's some interesting stuff here, hopefully. So, I mean, intellectual property is something that is, I guess, grown with more and more importance, and good to have a good understanding of it. And we'll explain throughout how it's growing. But I think with the digital revolution and the technological revolution and um, companies, value can be more in intellectual property than perhaps its assets itself. And so let's look at what intellectual property is. Well, it is any product of human intellect that is intangible but has value in the marketplace. So of course, human intellect is something that human intelligence and understanding configures and puts together something. So it's intangible, means that it's not physical. So it's usually an idea or a composition of some form or another, and we'll look at that in more detail throughout. It is called intellectual property because it is the product of human imagination, creativity, and inventiveness, or innovation, or so its importance. Well, traditionally, I think, as we've already said, businesses have thought of their physical assets such as land, building, and equipment as the most important thing. However, a company's intellectual assets are becoming increasingly more important, and you need only think of maybe Google as an example, where we can say that Google algorithm for Google is obviously much more valuable than all the buildings Google owns combined. The real value of Google is their search engine algorithm, and that is their intellectual property. That is an algorithm that the owners and founders of Google came up with. So just determining what intellectual property to protect if you're a business. So again, we're looking at it from the point of view as a business startup, as an entrepreneur, and we're also thinking about our own assessment that we have for this course, where we have to develop our own business plan and mobile application, and we have to think, well, what intellectual property do we protect? So, to determine whether intellectual property in question is directly related to a firm's competitive advantage. So, does that intellectual property add to the company's advantage? Does your idea, your creativeness, innovation, does it um, uh, relate directly to a competitive advantage? And then decide whether that intellectual property in question has a value in the marketplace. And that's how we determine what we have to protect. Just some mistakes that the companies have done in terms of protecting their intellectual property: not properly identifying all of their intellectual property. And in our last class, we talked about legal and ethics, and it's important, even when you're drafting a founders agreement, that intellectual property is identified and dealt with in an appropriate way, whether that one person takes credit for it, or indeed uh, that one person now signs the intellectual property over to the business. This is something that we decide at that stage. Not fully recognizing the value of intellectual property, and that is a common mistake. Not legally protecting the intellectual property. So it's all well and good identifying it, but we have to legally protect it, and not using the intellectual property as part of the overall plan for success. So let's look at some examples now in a moment of what it is, and I think that will help explain those things as well. So we've sort of seen already the four key forms of intellectual property, and we'll go through each of them: patents, trademarks, copyrights, and trade secrets. And they're all slightly different, and they protect different types of inventiveness and creativity, and we look at how they do that. So a patent, and the first thing we're looking at is patents, and a patent is a license or a grant from the government giving the rights to exclude others from making, selling, or using an invention for a set period of time or term of the patent. So, if you have a patent, it is not saying you are the only person that can use this. Rather, it is excluding others from making, selling, or using the invention. Because you might allow other people to use it if they're willing to pay you a license fee. So let's look at a proper understanding. And that's just the basic concept. A patent does not give its owner the right to make, use, or sell an invention. Rather, the right granted is only to exclude others from doing so. So as a result, if an inventor, and this is just a little example, obtains a patent for a new kind of computer chip, and the chip would infringe on prior patent owned by Intel, for example, the inventor has no right to make, use, or sell that chip. To do so, the inventor would need to obtain permission from Intel, and Intel may refuse permission or ask that a licensing fee be paid for this right to infringe on the patent. And while the system may seem odd, it is really the only way the system could work, because many inventions are improvements on existing inventions. And the system allows the improvements to be patented and sold, but only with the permission of the original inventor, who will benefit by obtaining licensing income in exchange for their consent. So, and I think that makes sense, just to reiterate that a lot of things are built on previous inventions, and if you weren't allowed to develop on a previous invention, well, inventions would become very limited. Three basic requirements for obtaining a patent: it must have a utility, which is basically saying it must have a usefulness. Novel, it must be different from what has come before. And not obvious, it must not be obvious to a person of ordinary skills in the field. So just three basic requirements. There's three sort of main types of patents we call utility, design, and plant, and we sort of have a type of inventions that are covered. So utility kind of covers process, machine, manufacturers. I'm going to say more business types are probably utility, but not all. Designs, invention of new, original, and ornamental designs for manufactured products, and then plants, any new varieties of plants that are reproduced. So a business method patent is a patent that protects an invention that is or facilitates a method of doing business. So you can actually patent methods of doing business as well. And some of the most notable ones would be Amazon.com. We have Pricelines, Name Your Price, and Netflix method of allowing customers to set up a rental list for movies to be mailed to them. While now antiquated, was a business method that they patented. And only Netflix could use that method. If you want, and you can look back in these slides, there is sort of different sectors and industries and different types of inventions that required patenting. So you can have a look through that yourself. Process of obtaining a patent: make sure the invention is practical. So we said utility, useful, etc. Document when the invention was made, hire an attorney, conduct a search, file a patent application, obtain decision from US Patent and Trademark Office. And I'm not sure if that is the same here in Bahrain. We will perhaps research that in our next class. Patent infringement takes place when one party engages in the unauthorized use of another party's patent. And the tough part, particularly from a small entrepreneurial point of view, is that patent infringement cases are very costly to litigate. They can put small companies out of business, and that has tended to happen in the past, where a big company, with endless resources puts a case against a smaller company, and difficult to defend because you just don't have the money to pursue the case. Trademarks, so that's patents. Trademarks is any word, name, symbol, or device used to identify the source or origin of products. And trademarks also provide consumers with useful information. So, for example, of course, we all know what to expect when we see a McDonald's restaurant, and think how confusing it would be if every or any restaurant could use the name McDonald's. And that's a nice simple example. We have here some types of trademarks, and they go through the trademark or service mark, and I think you can read these on your own. Just outlines the different types of trademarks. But what is protected under trademark? Well, you can protect words, numbers and letters, designs and logos, the Nike swoosh, the MGM Lions roar, fragrances, shapes, colors, and trade dress. The layout and decor of a restaurant can be trademarked. Things that cannot be trademarked: immoral or scandalous matter, profane words, deceptive matter, so labeling oranges, fresh Florida oranges that aren't grown in Florida, cannot be trademarked. Descriptive marks like a golf ball, a phrase like golf ball fried chicken, and descriptive can't be trademarked. And surnames cannot be trademarked. Obtaining a trademark: select appropriate mark, perform a trademark search, and create rights in the trademark. So that is trademarks. So we've covered patents and trademarks. Pretty straightforward. I think there's copyright is a form of intellectual property that protects the protection it grants the owner of a work of authorship. So the authorship, they've created something, the legal right to determine how that work is used and obtain any economic benefits from that work. So, it's usually, when we say authorship, I suppose the creation of a book, a novel, a music, whatever it is. A work does not have to be artistic in merit, so it doesn't. So you can do things like operating manuals, sales brochures. What is protected by copyright? Literary works, musical compositions, computer software, dramatic works, pantomimes, pictorial graphics, and sculptural works are copyrighted. The idea expression dichotomy, well, it's not that important, but it basically just says that, for example, an entrepreneur may have an idea to open a soccer-themed restaurant. The idea itself cannot be copyrighted. However, if you write down specifically exactly what the soccer-themed restaurant will look like and how it operates, the description can be copyrighted. Not too important. How to obtain well, probably is important. I'm dismissing that a little bit too easy. How to obtain a copyright. Copyright law protects any work of authorship the moment it assumes a tangible form. So if I write a book, and I have that in physical format, well, that is being copyrighted straight away. Technically, it is not necessary to provide a copyright notice or register work with the Copyright Office. However, I would say that is good practice. Copyright infringement occurs when one work derives from another or is an exact copy or shows substantial similarity to the original work. To prove infringement, a copyright owner is required to show that alleged infringers have prior access to the copyright's work and the work is substantially similar to the owners. You see an awful lot of it in music copyright infringement, but we're starting to see more and more, even in recent case there, I think, where there's an online bookstore, and I think, I don't know if it's Amazon for the Kindle, but any author can upload stories and books, and I think there was a particular case where some person was forging or rewriting a lot of pre-existing books and just changing names of characters. Yeah. The illegal downloading of music is an example of copyright infringement, and movies, and stay away from piracy and all that stuff. Trade secrets is any formula, pattern, physical device, idea, process, or other information that provides the owner of the information with a competitive advantage in the marketplace. So it tends to apply to businesses, business environments. Trade secrets include marketing plans, product formulas, financial forecasts, rosters, log of sales calls, uh, and similar types of proprietary information. Not all information qualifies as trade secret protection. In general, information that is known to the public or that competitors can discover through legal means doesn't qualify for trade secret protection. Companies protect trade secrets through physical measures and written documents. The strongest case for trade secret protection is if the information is characterized by the following. It is not known outside the company, is known only inside the company on a need-to-know basis, is safeguarded by stringent efforts to keep the information confidential, and you can read that, you don't need me to be reading it for you. Some physical measures for protecting trade secrets. So restricting access, and we see that more and more now in companies. Password protecting, our IT departments are constantly on top of us to improve our passwords. And again, you can have a look through these. And that's it. Nice and simple. Basically me reading the slides, but we will go into this in more detail and look at some better and further examples, I think, in class, and maybe get used to do a little bit of work on that as well. So yeah, that's where we'll leave it today. Just a nice short, as I say, a nice short introduction to um, intellectual property. So thank you, and hope you all have a good day, and talk soon.